I do have a legal analyst joining me today, a law school emeritus professor, Mitchell Hamlin, Joseph Daly. Joe, thanks again for sticking with us this morning. I'm just curious, these defense attorneys are going hard after these young teens who've admitted drinking that day. They're with Isaac Schumann. They do have to acknowledge they called Miu names that day. They do insist that at some point he said something that he was looking for little girls. You could perhaps see someone kind of saying that if someone was getting chirpy with him, like, oh yeah, I'm looking for little girls. You could see how that could be stated. It's not on camera anywhere, but they're insisting on it. Just your quick reaction to them having to sort of answer these questions from well-seasoned defense attorneys, including Corey Chirafisi there.
The defense has continued to question based on what their theory of the case is, which is they used the word surrounded by drunken, aggressive young people who were much bigger and much more fit than him. And essentially, the theory of the case is that he had no other choice. Being surrounded, he had to protect himself. Self-defense, he had no intent to kill anybody. That's the purpose of these tough cross-examination questions.
And Joe, you and I were texting back and forth on Madison Cohen, the testimony she can ask to opt out. Wisconsin fully open with their cameras. Perhaps some of our viewers surprised by that, but that is written into the law over there, correct? That a witness, and the state has actually called Madison Cohen, for the record, a victim here, not charged the crime against her. She's punched, but they did describe her as a victim early on in their opening statement. But she can ask for her testimony to go off camera, can she not?
Yeah, the judge cited a Supreme Court case, but during her testimony, I did a quick research job of the Wisconsin rules, and essentially the rules do say that the trial judge, on his or her own discretion or at the request of a witness, can cut off the TV feed. And I'm not sure why she asked for that, but she did, and the rules permit it. And apparently, I'm not sure what case the judge is citing, the Supreme Court case, but apparently there is a Supreme Court case.
And the judge did make a record of that, and then we understand we're sharing this pool feed. There's only one television camera in that courtroom in Circuit Court in St. Croix County, and obviously the judge killed the microphone there, so we could not hear Madison Cohen's testimony. Joe, one more question. I know you want to get you on to lunch here, but strengths and weaknesses each side. I know you've been watching. We're a day and a half in. We've seen 6 state witnesses take the stand. Some emotional stuff this morning from Isaac Schumann's mother, obviously there. We saw emotion both from the young man who shot the video, Jawan Cockfield, Alex Vang, who was just on the stand there talking about treating or trying to treat Isaac in the moment. A lot of emotion. I know that's one aspect of what this jury has to sift through, but I know you want to talk strengths and weaknesses so far. If you could sort of sum up one or two on either side that you're seeing at this point, again, a day and a half into this trial.
I think the key strength of the prosecution's case is that he surely could have walked away. He could have gone. He could have left. And even when he was supposedly surrounded by these 2 women, he certainly could have turned and walked away from them. I think that's a very strong case. The emotion of this case also adds strength in terms of, for example, Mr. Vang's testimony was when Isaac went down into the water, and Mr. Vang realized, he put his hand on his heart to try to stop the bleeding, and then he dragged them to the shoreline. He was quite emotional during this. That certainly weighs in a jury's mind about this whole thing. The strength of the defense case is that they've laid it out in this cross-examination of Mr. Vang. He was surrounded. He was knocked down. He was pushed down. He was in the water. And he felt, I assume he's going to testify, that he was in danger, um, uh, maybe of being drowned, maybe who knows? And then these drunken, pot smoking kids were yelling at him and saying he was a rapist, and so his defense is clearly going to be, I felt like I was in grave danger. That's the strength of the defense case.
I find it really interesting because the state and their openings and how they're trying to tell this story is, as you said, Nicolae Miu could have avoided the whole situation, stepped out of the river, gone up the river bank, just not engaged whatsoever. He did not have to walk back up through the water back towards his group that would have been upriver from the young tubers. But the defense in their cross-examination have seemed to find this one piece of video where it's almost like Miu has stepped to the side a little bit, opening up the river, flowing downstream, saying to the kids, why didn't you guys just stay on your tubes and float right on by? And I think that, at least in my mind, has created some question about, could they have avoided it? The state keeps saying Miu could have avoided it, but could the young tubers have avoided the escalating confrontation with Miu? I don't know if you picked up on that during the Turfsey cross-examination.
Well, the reason for that cross-examination is, again, Mr. Miu could not avoid it because the kids were there and they weren't moving. They could have easily floated by. This is, when I watched the opening statement, I didn't follow this case other than reading what I read in the newspaper and hearing on TV 2 years ago. But when you asked me to be a commentator on this, when I watched the opening statement of the prosecution, I thought that they're going to win. But then when I watched the opening statement of the defense, I suddenly thought, oh, this is a tough case. This is not an open and shut case at all. The jury's going to be asked, if they can, to put aside the emotion and basically make a determination of the facts of this case. Was it reasonable what Mr. Miu did? Was he really surrounded from his perspective? Did he really feel in danger? Those are tough questions, and there's still more testimony to go. And then they're going to be looking at this video more than a few times. This is a tough case. This is a tough case.
Yeah, and Joe, not just a well-seasoned, educated legal mind like yourself, but just in the community, as I've spoken to people, once that video was shown, it just seems just complete division on what people see in that video. Could it have been avoided? Was Miu right to pull out a knife? He eventually certainly gets in a position that would be quite scary to anybody, but what escalated it, who threw the first punch, those kinds of things. I haven't asked you this question. It is charged at first-degree intentional homicide. It's the top count, a Class A felony in Wisconsin. It would send a defendant to prison for life if convicted. I am just curious. It's the top count. The state can adjust down the road here, amend the complaint to perhaps give the jury some, as you're looking at the screen now, with the exact charges. I'm just curious about charging at this count, just given the immediate reaction you, me, those in the community I just spoke about are having to that video. Are you surprised the prosecution would charge at the absolute top scale of murder in the state of Wisconsin here?
I'm not surprised because it's a young kid. A grown man slashing out with a knife, a grown man punching allegedly a woman, a grown man looking for little girls. If the jury thinks all of that is true, intentional murder is the strongest charge, and when the prosecution is making a decision to charge, they certainly could have. It's understandable, it's reasonable why they would do that, but if they don't, at least in Minnesota, I'm not exactly sure in Wisconsin, but it's almost like they're going for all or nothing. they're going for a conviction on murder in the first degree with a life sentence, intentional murder, and not looking to charge him for something less. As these facts have developed, I think it's going to be hard to convict this man of murder in the first degree from what I've heard so far. And then I believe he probably will take the stand. I certainly know if I was his lawyer, I'd put him on the stand. He doesn't have any criminal background. He's an engineer. I just think he speaks a number of languages from my understanding. And so I think it's necessary to put him on a stand. And then the jury will hear how he saw this, how he saw what was happening when he got pushed down. But again, he has a right not to take the stand.
Right.
And you can't compel him to testify against himself. But at least based on my own experience of being a lawyer, my judgment would be he has to go on the stand.
Yeah. And his attorney hinted at that. He wasn't quite as frontal as I've seen in other self-defense cases where they, tell that jury specifically, he will be on the witness stand, he will tell you. But he did say within that opening statement, I did catch one point where he did say, Mr. Miu will tell you, or he will say. So the expectation certainly was opening the door, if the jury was listening closely, to eventually seeing Nicolae Miu on the witness stand and having to explain exactly what he was feeling, what he was thinking. And frankly, Joe, as you've listened with us these last couple of days, is he does have some repairing to do in his story. He has clearly lied to authorities after his arrest. It was his knife. He did not take that off anybody. He discarded the knife, why he walked away. I mean, there are holes in the defense case in terms of some of the things that have been presented so far. So, I know the attorneys can repair during opening and closings, but certainly I would think a jury is going to want the whole picture before weighing in on his fate.
Well, even in the opening statement of the defense, his lawyer admitted that it was a lie when he said it wasn't his knife, and the reality of the human experience is when you're in trouble, a lot of times people don't tell the truth, but certainly they're going to have to deal with that, because then the jury will think, well, is he lying about everything? Yeah. Is any of this true? So, like I said, it's not an open and shut case by any means.
Not at all. Joe, thank you so much, Professor Daly. I appreciate you joining us for the lunch hour. We'll see you hopefully later today, maybe to wrap up the day testimony, as we do have this lunch hour. And we've talked about some of the emotion. I think it's important to go back to some of the witness testimony we saw earlier today. Isaac Schumann's mom on the witness stand, also Alexander Vang, just capturing some of the emotion today of what everyone in that courtroom had to experience.
You're welcome. Thank you, Paul.